excused, but it's, I mean, just not doing it. I don't have a good excuse. There've been a few times I forgot. I haven't been home, but nothing that's excusable.
All right, do you want to go to prison?
No, man. I have a 17-year-old who depends on me, and I'm doing really well. I actually divorced because of her substance abuse, and I've been doing really well.
Well, I mean, you're acting as though you want to go to prison because you don't have any good excuse for not abiding by these conditions. And this has been going on since 2020, 24.
Yeah, there's no good excuse. I mean, my first probation.
3 DWI charges, a plea deal, and a man who says he's 5 months sober, but just violated probation again. This is the courtroom drama of Brian White, a father, a repeat offender, and someone who's dangerously close to throwing away everything he claims he's rebuilt. But here's the twist. Despite 3 DWIs and multiple violations, he keeps getting second chances. Is the system being too lenient, or is this the last stop before prison? You'll hear a judge lay down terms a father fight to stay free for his son, and a very blunt warning about the cost of drunk driving, and just when you think it's over, he's back in court again. Same case, different violation. Stay locked in. This case will make you question how justice handles repeat DWI offenders. Let's dive in.
The court is calling 2022 CR 8045, State of Texas versus Brian White. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Julie Pollock.
And are you Mr. White?
Yes, ma'am.
Mr. White, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of driving while intoxicated third or more as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Next, I'm going to show you what's entitled the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I do.
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There's a $1,000 fine.
Brian White pleads guilty to his third DWI, a third-degree felony, and the punishment could have been up to 10 years. But here's where it gets complicated. Instead of prison, the state recommends probation, including interlock devices, meetings, parenting classes, and even a COVID vaccine incentive to waive community service hours. What do you think? Is this tough enough for a third DWI? Or is the system bending too far to offer second, third, and fourth chances? Comment below. Would you feel safe sharing the road with someone like this?
Be for a term of 5 years. There'll be a TAP evaluation, 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
Yes, Your Honor.
State any evidence?
Your Honor, state all for state exhibit 1 in all attachments.
No objection.
The court will accept into evidence state exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
We would just ask that you follow the agreement. Now, my client, he's done approximately 120 days in jail before he bonded out. We would ask that you give him credit for that time he spent to satisfy
The judge officially accepts the plea, and here's a subtle but powerful moment. White's attorney emphasizes that he already spent 120 days in jail. It's a smart move. They're trying to count that time served against the 10-day jail requirement. And you can see the strategy, paint him as someone who's already paid, who's got a job, a kid, and stability. But here's a legal reality. Prior time served is often credited during sentencing, especially when plea deals are involved. Smart lawyering? Absolutely. But ask yourself, should time served before a formal sentence count as part of probation?
on probation. I think he's going to AA meetings now. He's taking care of the issues that he has, so we would ask that you follow the agreement.
All right, how did you get here today?
I was given a ride by my dad.
Where's your dad?
He's at home now. I can take the bus.
Okay.
But you're on, I am 5 months sober. Like she mentioned, I was incarcerated for over 90 days, and since then I have abstained from alcohol and continuing to go to AA meetings. And being away from my son for that long has kind of put things into perspective. So no intention of going back to drinking. Part of that was being in a toxic relationship.
This part hits emotionally. White's attorney brings up his son, just 14, now on the AB honor roll. A subtle play for sympathy, but also a reflection of what's at stake. White says he's 5 months sober and seems to take some accountability. But then he starts blaming the past, a toxic relationship, his ex-wife's addiction. Listen closely. This is a key moment where the judge starts to push back. Would you accept this as honest reflection or an excuse wrapped in vulnerability?
Probated for 5 years, $1,000 fine, probated, concurrent with County Court Cause number 645329, DWI intervention, VIP live, ignition interlock for 2 years, 2 years Texas driver's license suspension. There's to be 90 sober meetings in 90 days, 150 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 hours will be waived. Parenting classes, the remaining of the hours will be waived once you complete parenting classes. There's going to be regular reporting by Zoom or in person. I'm going to want field visits once per month. Probation, we'll do that for 3 months. If there's no issue, then you can do field visits as needed. I'm going to want a TAP evaluation. If the TAP evaluation recommends inpatient treatment, we'll start off with
Now the
intensive.
sentence, 8 years suspended, 5 years probation with an intense list of conditions. 90 AA meetings in 90 days, parenting classes, GPS tracking, ignition interlock, outpatient therapy, even COVID vaccination in exchange for fewer service. Hours, this is what's called a structured probation, heavily monitored with multiple checks for compliance. But let's pause here. Is this overcompensating for not sending him to prison? Or a legitimate effort to rehabilitate without tearing? A father from his son?
Care provider or with minors. Probation, is there anything else he needs? Thank you. And we'll do regular UAs. And make sure they test for alcohol. All right, is there anything else you need from the court in order to be successful? All right, good luck to you. We can go off the record. Here's the thing. This is what I've discovered. My statistics professor will be disappointed in me because I haven't done an actual study of it. But usually when people are driving intoxicated and they end up getting in a car accident, you know who ends up getting hurt? Their passenger, somebody else. It could have been you driving and your child is in a car with somebody else and you end up hitting them and killing them. Don't be that person. You understand? All right, good luck to you.
Thank you.
All right. Court is calling 2022 CR 8045, State of Texas versus Brian Christopher
The
White.
court layers and more. No home health work, no working with minors, and mandatory alcohol testing. The judge is building a tight fence around White's future. But one thing stands out. She asks, what else do you need from the court? To be successful? That's a powerful question. Judges don't just punish, they also set expectations. Would more judges get better results if they took this kind of proactive tone? Let us know in the comments.
Third or more on November 7, 2022 for a term of 5 years.
Yes, ma'am.
All right, state.
State would like to orally amend violation of condition number 15 to read ignition interlock rather than hand device.
We have no objection on that.
All right.
On or about the 15th day of December 2024 in Bexar County, Texas, the defendant Brian Christopher White did then and there fail to comply with the rules, regulations, or instructions of the ignition interlock device in that the defendant failed to provide daily samples in violation of condition number 15.
How do you plead to that? True or not true?
True. State waives the remaining violation allegations, Judge.
Any objections to the waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, and sentence you up to 8 years in prison and up to $1,000 fine? Knowing that, do you still wish to plead true to violation of condition?
Fast forward, White is back in court, new violation. He failed to comply with his ignition interlock device again. The thing that keeps drunk drivers off the road, and he didn't use it. And what does he say? There's really no good. Excuse? That might be the truest statement he's made all day. Automotive issues, cold weather, forgot to blow into the device. This isn't just a technical slip. It's a violation that could have ended in tragedy. Should one failure mean jail time, or do repeat violations tell us he's out of second chances?
Brian Christopher White.
All right, why are you not following through with ignition interlock?
There's really no good excuse. There've been a few automotive issues, but it's, I mean, just not doing it. I don't have a good excuse. There've been a few times that I forgot. I haven't been home, but nothing that's excusable.
All right, do you want to go to prison?
No, man. I have a 17-year-old who depends on me, and I'm doing really well. I actually divorced because of her substance abuse, and I've been doing really well.
Well, I mean, you're acting as though you want to go to prison because you don't have any good excuse for not abiding by these conditions. And this has been going on since 2020, 24.
Yeah, there's no good excuse. I mean, my first probation officer, I didn't ask, and she didn't say about how many times I had to.
Watch how the judge reacts. You're acting as though you want to go to prison. That's not drama. That's frustration. And it's earned. White admits he didn't follow the rules. Again, the judge reminds him, we've been here before, and this is key, judges remember repeat offenders? It's not just a case file, it's a pattern. Would you trust someone like this to stay sober? Or has probation become a revolving door?
Again, I guarantee that.
I think that's what you said the last time. My mind is a steel trap.
This is my first.
This is first MTR in the court. He
No,
had some
we-
supplementals.
Yes, and I do compliance hearings
Yes.
and I tell
Yes,
people to
Your
get their
Honor.
life in order. All right, this is what the court is gonna do. And state your excuse. The court is gonna deny the motion, alter and amend conditions for a 6 months extension. And there's gonna be 3 days in the Bear County Jail starting today. All right,
Like, where I can help someone to take care of my son.
okay.
Is the 6-month extension on the probation supervision or on?
Yes, on the probation supervision.
Okay.
And then 3 days in the Bear County.
The final ruling, 6-month probation extension and 3 days in jail, starting immediately. Even here, the court shows flexibility, letting him call his job, make arrangements for his son. But one big takeaway, this isn't about punishment. Anymore, it's about accountability. The judge even notes, you will never see me again. Let's hope that's true, because next time, there may not be a ride home. Would you have made the same call or thrown him straight into that? 8-year sentence?
Deputy Mejia?
Yes, Judge.
He'll need to call, he's gonna go into custody today, but he'll need to call his work and his parents.
Yes, Judge.
So I'll be out by Friday, so I won't have to miss work next week.
No, you have 3 days. And counsel, you can come back and check in with the court on day 3 to make sure that he's been released.
Yes,
Yeah, including today is part of the 3 days. No.
You're going in today, but this is not a full day. And the reason why I say that is because the jail is probably not gonna count this as a full day. So you'll be out on day 3, but not at the beginning of day 3. So for example, usually they release people at midnight because of when I'm placing this order and the time it is. They're not gonna release you at midnight. They'll probably put it in like 3 to 4 more hours, but you'll be released on day 3, but not in the morning at 12 a.m.
Okay.
So here's the full picture. Brian White, a father, a repeat offender, was given a second chance, then violated it, then got another. The judge walked a fine line between compassion and accountability, layering strict conditions while avoiding a full prison sentence. Was this the right call? Or is the system being gamed by someone who just says the right words? Let us know what you would have done in that courtroom. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns right here on this channel.